And hello, welcome once again to the Disability Law Show. Good to have you along for the half hour. I'm John Scholes. James and Tamar are both here. Samfiru, Tumarkin, LLP. Reach out anytime you want. 1-855-821-5900. Help at disabilityrights.ca. That is the email. Try to get to a few of those over the course of the 30 minutes. If not, we got all kinds of stuff to talk about anyway. And always feel free to reach out to James and Tamar anytime. It won't cost you a dime to pick up a phone and ask some questions. We always have a main topic on the show. Today it will be 3 benefits of applying for CPP disability while on LTD. Important stuff, and you may be surprised by the comments that come from James and Tamar in that regard. They've got their own stuff to talk about, of course, over the half hour, so let's get to it, guys. James, week that was. This week it's going to be you. What do you got?
I got it.
All right.
So this is a theme that comes up quite frequently on our shows. And it's not accepting what the insurer tells you just because they're an insurer and you think that they've got more experience doing this. If you are disabled, if you are not able to work and your doctors have confirmed that you can't work, you can't work, even if your disability insurer tells you that you can. And I've got a perfect example, case that I just went through. So this is a gentleman out in BC. Very long history of back pain, a degenerative condition. It was getting worse over time, as you would expect it to do, to the point where his employer had been providing him with accommodations over the years. First, it was just an ergonomic desk. As things got worse, a sit-stand desk, certainly the ability to change positions as needed, even lie down in his office when required, and at one point went from working 5 to 4 down to 2 days a week. And eventually the employer said, okay, we can't continue to accommodate it 2 days per week. And so he went on disability leave, as you would expect. And he was initially approved for short-term disability and then long-term disability. About 18 months after started getting long-term disability, the disability insurer all of a sudden says, you know what, you can actually go back to work. And sends him a letter saying, as of this particular date, your benefits are cut off. All you need is for accommodation so that you can change position when necessary. Sounds strange, no? Because it sounds a little bit like the accommodation that he had for a couple of years before going on leave. And so he hires me, and I get the file, and I take a look through it. And of course, they went to a medical consultant first. In this case, it was actually a doctor, but a family doctor, one who had no particular expertise in the medical areas relevant to the case. And certainly he had never met my client or assessed him in person, and apparently hadn't really reviewed the file terribly well, or wasn't or possibly the insurer didn't give him the whole file. I don't know. But came up with the brilliant idea that all my client needed was the ability to change positions, which of course was never the issue at any point in time. And so they cut off benefits. And so this is obviously an egregious mistake for the consulting doctor to have made, but possibly he didn't get the whole file. Whether or not the doctor's error can be excused is kind of irrelevant, because the insurer's error in accepting that opinion certainly cannot. The insurer, regardless of what the doctor has said, was well aware that my client had been getting accommodations all the way through and that those accommodations remained available. Of course they were. What employer isn't going to say you can sit and stand whenever you want to? The reality is, when you have functional limitations like my client had, in this case, he couldn't sit for more than 30 minutes at a time, couldn't stand for more than 10. And we see those types of functional limitations frequently. When you have those types of functional limitations, there really isn't any type of job that you're going to be able to do. Sure, maybe you could sit for 30 minutes, stand for 10, and maybe you could go and sit for another 30. And maybe on a really good day, you could do that a third time. But that's generally going to be it. Then you're going to have to go and lie down. This is what I hear consistently from all my clients that have these types of limitations. There is no reasonable way anyone can expect you with those types of limitations to work an 8-hour day, 5 days a week after week, all year. It just isn't going to work until those symptoms improve. And with a degenerative condition, they're not likely going to improve. And so they had a lot of exposure in this case, and let me assure you, they paid. The point of this is that just because your insurer is telling you that you're okay and you can work, and even if they're saying that their doctors are saying that, doesn't mean they're right. And if you know they're wrong, then don't leave it. Challenge their decision.
Tamar, it seems kind of weird that they, this person that James is talking about, their doctors, like they never see the client, they haven't maybe not read the whole file or received the whole file, yet they're throwing out their opinion. That doesn't seem to hold a lot of water, no?
And it doesn't. And this is the fact that the courts, in the few times that they've actually weighed in on these kinds of claims, because we don't see a lot of judgments in our world, but in the times that they have, John, they've agreed and deferred to the treating doctor in making these kinds of determinations. And so, yet we see routinely insurers getting a medical review, just the paperwork, maybe part of the paperwork, as James has commented on, and then accepting that. The adjuster will accept that over what the treating regular doctor may say. Even some other health practitioners, they always prefer the MD over the, say, the physiotherapist or the chiropractor, who, quite frankly, most family doctors will defer to in these kinds of assessments to assess this kind of function. I also think it's quite surprising when they don't actually take the additional step, the insurer that is, to actually get individuals like this assessed. Because they know, I think, frankly, even though we don't see it in our files, they know what that assessment's going to hold. It's going to hold that the prolonged nature of whatever it is physically that this individual cannot do has been highlighted by whatever testing that the insurer has put them through. So it's much easier for the insurer to justify closing out their claim on the basis of a paper review when you've got a physical disability, because that is what they are prescribed to do, and that is where they lead to these claims and put it right in the denial letter. And I wholeheartedly agree with James that the inclination for individuals, John, is after they've been through so much and still experiencing health issues, when they get these letters from the insurer, the inclination is to just simply accept and give up and not actually pursue your legal rights. And that's what we want to discourage individuals from doing, is that the courts will agree with your family doctor and whatever practitioner. And in fact, that's very helpful leverage when we go ahead and start that legal claim, if you give us that opportunity to do so. So I cannot agree with James enough on this kind of situation. And the profile that we see quite regularly, where it's like a minefield of errors, and we leverage that in terms of getting that resolution.
100% of the time, if you're treating doctors, particularly specialists, are saying one thing, and a medical consultant hired by an insurance company who has never met or assessed you says something else, a judge is going to side with the treating doctor. They know you better. They have specialized expertise if they are in fact a specialist. It wouldn't make any sense to do otherwise, and the insurers know that.
Does it ever backfire? The hired gun ever come back and say, no, this guy can't go back to work?
So we see that actually quite frequently when they do assessments, which frankly is part of the reason why they don't pay to get the assessments, because one, it's going to cost them money, and two, you're probably going to get a more impartial result, not necessarily entirely impartial,
okay,
but it's closer to, because it has to be. They've actually seen you in person, and they can see the limits of what you're able to do. They can't just sort of skip over big parts of a file and find the things that they want. Right. So it becomes much harder to justify ignoring what's right in front of you.
Another tool that you can use anytime to reach out to James tomorrow afterwards, called pocket-disabilitylawyer.ca. Tamar, I know you talked a little bit about this. You're kind of in favor of it. What do you think?
I am in favor of it because it sort of grew from our pocket employment lawyer. You know, we've got these two amazing areas of practice that we're in at our firm. And so this, again, is a similar tool, very easy to use, drop-down menus, and you plug and play, and it's completely anonymous. So if you're looking for a starting point on, look, do I have a basis for a claim? Should I be contacting a lawyer? You absolutely can use this tool, but if you don't want to speak with one of us, that's okay. You actually have that button to click to say, no, please don't contact me, and we're none the wiser. But it's, again, an effort, John, for us to push out as much free information and anonymous information out there for individuals, just to try and level the playing field a little bit with insurers and claimants.
And as mentioned off the top of the show, another way, yet again, to reach out is email. That is help@disabilityrights.ca. Guys, the first one for today comes from Danny. Danny says, I had a bad slip and fall accident that left some lingering injuries. It was impossible for me to do my job, so I went on LTD. The insurance company just called to say that they had me under surveillance and saw me walking normally when going to the store. That's not true. I still have trouble walking and use a cane. Are they going to cut me off?
Well, they might cut him off, but they shouldn't cut him off, because these things can be quite nuanced, right, John? What we don't have from Danny's email, unfortunately, is what is the true nature of the disability? What are those limits? How often is he using the cane? Does he require the cane? But those things are very important. The devil sometimes is in these details. And so when we see claimants who potentially got cut off as a result of surveillance, it doesn't deter us from taking on these claims. We can absolutely challenge the insurer. But what has been reported by Danny and his own doctors and his own medical team becomes very, very important. Insurers are very cynical, and they use these kinds of tools to try and attack credibility, try and attack the underpinnings of someone's disability claim, because frankly, they just assume that everyone must be making these things up. Nothing could be further from the truth. And so the context in which they get this kind of surveillance and how they use it by the insurer becomes really, really important. Now, Danny shares with us that, I still need, the cane, I'm doing ongoing treatment. And so what is also important is, if the insurer takes that additional step to cut him off and uses this surveillance as a basis, what else is the insurer saying? Has the insurer suggested that perhaps you don't have appropriate treatment or there are other options? Is the insurer going to rely upon it to say simply that we don't think you're disabled under the policy anymore? Those kinds of issues that are in that denial letter become really important for lawyers like us to try and determine and really craft that basis of a challenge. The last point I wanted to make on Danny's email, and I'm sure James wants to add a couple comments here too, is that it arises out of what we call a tort claim. He had a slip and fall incident. Now, could it have been at his own home? Perhaps, but was it on a public property? Was it on municipal property? We actually deal with those kinds of claims as well. And the reason why that element is also important is because if individuals are injured in this manner, not only do they have access to long-term disability if they're employed or perhaps they have an individual plan, but they could also have an opportunity to pursue if there was negligence causing the slip and fall incident. So in other words, if there was a wrong done that then ultimately resulted in Danny injuring himself on this fall, there could be another avenue of compensation. James?
Got a couple of minutes, James.
Yeah.
Well, so if there is any issue that comes up in the context of disability claims from start to finish, from application through to denial, litigation, what have you, that is given a disproportionate amount of time and effort and anxiety by people in the process, it's surveillance. People who have not had experience with this process think that there is surveillance happening all the time, and as soon as there's surveillance, they're done. And really nothing could be further from the truth. Surveillance is done maybe 5–10% of the time, if that. It's expensive. Insurance companies do not like to spend money. And the reality is, as Tamar was alluding to, when we get the insurance file and we see the actual surveillance, it is very rarely going to do anything to harm the claim. Sure, if you are in fact working and say that you can't, yes, surveillance catching you do that is going to destroy your claim, as it should. Yeah. If you have said that you absolutely cannot do something and the surveillance shows you doing it, then yeah, that's going to, at the very least, really damage your credibility, which is of course going to damage your claim. But if you are being forthright and honest throughout, you have nothing to be concerned about whatsoever with surveillance. Now, that doesn't mean your insurance company won't go out and hire an investigator. And it doesn't mean that even though there isn't really anything there, they won't try and use that, if they happen to get surveillance, to justify termination. But if they go through that process and it's a generic surveillance that really doesn't show anything and they try and cherry pick things, there's absolutely a lot we can do with that. My experience, and this is true I know for Tamar as well, when I get surveillance, I'd say 90% of the time it helps the case. 90% of the time it shows that my client isn't doing much of anything day after day after day. And that is very compelling evidence of disability. If you are at home, not leaving your house, doing nothing, then you are most likely not going to be in a position to be able to go to work. Now, it doesn't determine anything one way or the other, but it is pretty good evidence that you're not really able to do anything if, in fact, you're not.
Let's take a short break now that we're warmed up. On the other side of the break, 3 reasons why applying for CPP disability while on LTD is a good idea. That's on the way as we continue with more of the Disability Law Show. Hang in there. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back, Disability Law Show. That's where you've landed. Good to have you along for the remainder of the half hour. James and Tamar, Samfiru, Tumarkin, LLB, that's where they are. Want to reach out to them anytime to have a conversation on your own. Invited to do so. Won't cost a dime to pick up a phone. 1-855-821-5900. help@disabilityrights.ca. That's the email address we use every show. But guys, main topic as mentioned, I love this one. 3 benefits applying for CPP disability, Canada Pension Plan disability. While on LTD, which you qualify for if you pay into it. James, first you. If approved, it can strengthen your LTD claim. Break that down for me, pal.
Sure. Let's talk a little bit more generally about CPD,
Yep.
CPPD first, Canada Pension Plan Disability. So again, as you mentioned, if you've been paying into the Canada Pension Plan and you become disabled, then you have the ability to apply for CPP disability. The test is a little bit different and frankly more onerous than it is for a disability policy. It requires a prolonged and prolonged and severe disability, which is certainly a much more difficult test to pass than being disabled from your own occupation in the first 2 years, any occupation thereafter. So when we say if approved, it can strengthen an LTD claim, what we mean first and foremost is that if the federal government is saying that you have a prolonged and severe disability, that is, as we said, a more difficult test to pass. If the federal government says you pass it, it puts the insurance company in a difficult spot to say that you don't pass their test, which is an easier test to pass. Right. They'll say otherwise. They'll say, well, they're different tests. They don't mean the same thing. I'm having none of that. The CPP disability test is a more difficult test. I don't care if they say it's not, it is. And that doesn't mean they're bound by it. They're not. They can come to their own conclusions, but it does put them in a more difficult spot. And certainly when they've denied it and then subsequently the CPP disability approves, they know they have egg on their face and you know they're coming to the table in those scenarios. So from that point of view, it certainly does make it stronger. Likewise, if you are approved, what happens is your LTD policy is going to have a provision in almost all cases that requires you to apply. And so if you are approved for CPP disability, what it's going to do is actually relieve your insurer of whatever amount you're approved for in CPP disability. And so on the one hand, you're thinking, well, what's the point of this? Why should I bother if it's just going from the government to the insurer? And there's some logic to that. But the reason why is because if you don't apply for it in the first place, then the insurer can just estimate what you would have got had you applied and been approved and just take a deduction for that. That's written into the policy. So you don't want to give them that option. And if you apply and you're approved, not only is the stronger test good evidence that you're also that you should also be approved for the LTD, but it makes it a little bit easier for the insurance company to continue paying those monthly benefits because it's not costing them as much. Right. So you're less of a liability to them. It just makes it more likely that that's going to continue further than it might otherwise.
So Tamar, now we've gone past the process you're in there. Whilst on CPP, disability can help you if your LTD benefits are cut off. This is the whole thing with the money balance, right?
It is, and this is what James was referencing as well, is that there are financial benefits and substantive benefits, for lack of a better term, okay? And so the key financial benefit is that you will continue to receive your CPP disability benefit regardless of what the long-term disability insurer is doing with your claim. Those are two independent processes. Now, what can also help is, and this is what I mean by substantive, is that idea, exactly what James said about the test arguably being tougher. So if the insurer is taking the position that you no longer meet their test for eligibility, you're no longer totally disabled, when one of us gets involved, we're going to use the CPP application and approval as leverage for that test to say, well, surely if they've been approved,
this threshold, right?
Exactly, John. But I'm going to take it one step further, which is this. There are a couple of insurers who will routinely, during the adjudication process, actually send a letter out to the insured while they're on claim saying, look, you must apply for CPP disability. And we're actually going to help you through that CPP application process. And so when we pick up that file and we see these letters, the timing of when these letters get sent is also really strategic for us to say, well, insurance adjuster, surely you must have believed then that this individual was totally disabled and had a severe and prolonged disability in order to initiate the process of that letter, that standard letter that says you must apply for CPP, and also taking that additional step to actually help them with that process. But hang on, as soon as they got denied or as soon as something changed, 6 months later you're telling them they're not disabled anymore. The chronology is exactly, right? And so the chronology really, really helps us in our legal claims to sort of assert this back to the insurer to say, this is not a left hand and a right hand, and no, you've got two hands and the same limbs, and you've got to have a consistent approach here, for a lack of better, analogy. And this is why we think generally that the CPP application and the approval for that, the pros always outweigh the cons.
That's also why I'm not a lawyer, because that's pretty smart. I never would have thought of that. James, applying for CPP disability protects you from unnecessary deductions or presumed credits. What does that mean?
Well, I stepped all over this when I answered the first question, to be quite blunt. So what it means, again, is the policy is going to have a provision that says if you don't apply, they can take that deduction based on their estimate of what you would have gotten. So we've covered that, but there are a couple other benefits to doing this as well. If you apply for CPP disability and you are approved, sure, it's money coming in and then just being deducted off what your insurer pays you. But when your insurer cuts you off, eventually, when they do, and you bring a lawsuit, you're going to have to pay legal fees. Whatever you're recovering for in CPP disability, you don't have to recover from the insurance company. So that's going to save you money in legal fees down the road. Big benefit. Another thing just to be aware of, if you are applying for CPP disability, unless you have a particularly obvious prolonged disability, something where, let's say you become a quadriplegic, sure, you're not going to be working, and the government's going to accept that it's a severe and prolonged disability, sure, you can apply right away. But for a lot of other disabilities, particularly, unfortunately, when we're talking about mental health, it takes a while before you get to the point where a government would accept that it's both severe and prolonged. And so without that, you probably want to wait a little while until you apply. The one downside to CPP disability is that it is a taxable benefit. So if you're getting it, you're going to be taxed on that. If you have a non-taxable policy, then you are actually winding up with less money in your pocket, because if you have $1,500 from CPP disability that's now taxable, and that $1,500 is coming off your non-taxable LTD benefit, you're short. There is a solution.
Tax credit.
The disability tax credit, which, because our government is super efficient, is run by a different bureau of the government. So you do have to apply separately to both of these. But yes, if you're applying for CPP disability, I would strongly recommend also applying for the disability tax credit. The test is reasonably similar. Doesn't mean you're going to be approved for both if for one, but it makes a lot of sense to apply for both at the same time if you're doing.
All right, we dissected CPPD very well for this particular show. We'll take a short break. More of your questions coming through on the other side as we continue the Disability Law Show. Hang with us. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back to the Disability Law Show. I'm John Scholes. James Fireman, Tamar, Agopian, always reachable and willing to have that conversation with you. The phone number is 1-855-821-5900. Email if you prefer that, or in combination with help@disabilityrights.ca. Yet another way to reach out is mydisabilityquestions.com. That's a nice website because the algorithm works like this. Your question may have been asked previously and answered. That'll save you some time. If not, type your question in there, and either one of these two or their team will answer it. For this week from mydisabilityquestions.com, guys, is Christine says, I'm currently on LTD. My doctor has recorded completely different information in my medical records than we discussed at the appointment. For example, his notes from my latest appointment say that I was feeling better overall. At no point did I state that my back pain had lessened, only that I had gotten used to it. Should I suggest he speak to a disability lawyer? I'm worried this will lead to a cutoff of my benefits.
So this is an interesting one, and one that doesn't necessarily have a linear answer. And so what I want to suggest to Christine is that, yes, absolutely, we're more than happy to speak with doctors and medical practitioners about how to prepare their patient, what to write, what to do with the documentation that the insurance company is sending over, so that you can put your patient in the best possible position to try and get their either benefits approved or continue having those benefits received. The challenge, though, that Christine is facing here is one that, you know, perhaps could be assisted by a conversation with one of us, but maybe not. I mean, look, John, these medical practitioners have their own duties and obligations on what to record, how to treat their patients, and certainly we as disability lawyers really do not want to get in the middle of that, nor dictate to any sort of medical practitioner as to what they should record. But it becomes extremely important that what Christine is reporting is actually accurately reflected in what the doctor is sharing, because that information inevitably is going to be sent over to the insurer. And if the insurer is sort of understanding that there's improvement, perhaps to the point that she's capable of working, then yes, the insurer will use that information to deny or cut off Christine's disability claim. And so we've created some helpful tools, and I think I want to make reference to a couple of them. We've got some good memos on one of our websites called ltdfaq.ca. One of them is a guide for treating practitioners in terms of the type of information that should be contained in reports for the insurer. That could be a good starting point for Christine. Grab the memo, have a discussion with your family doctor, whoever it is that's helping you with your disability claim with the insurer, and just talk it through and say, look, doctor, therapist, whoever it is that's in Christine's world as treatment, this is the reality I'm facing. Are we on the same page on my ability to work or not work? And can you prepare a comprehensive report for my insurer to explain the nuanced aspect of what you've commented on, which is I'm dealing with the pain, but I'm still not able to work.
Right.
James?
Last comment, yours, pal.
Well, I'm not sure that it's a dire situation. It might be, but if this is just one record from, let's say, the GP on one particular day, even if it's wrong, it is just one record. People have good days and bad days. And presumably, if the disability is bad enough that Christine's been approved for LTD, she probably is seeing other doctors, perhaps specialists. She probably is seeing therapists of some kind, maybe physiotherapists or what have you. And those records might be more complete and more frequent and might show a more accurate record of the trajectory of her symptoms. Cool. And so, yeah, could the insurer take this out of context, incorrect or not, and say you're cut off? They could. I don't know that it's especially likely that they would in this case. And even if they did, it would certainly be something where, as long as there are other records out there that are showing otherwise consistently, then there'd be a pretty good basis to challenge that decision from the insurer and say, no, look at all these other doctors' notes that are saying, no, she's not feeling well day to day. Even if she was there, who cares? It's one day at best.
That's right.
There you go. We jammed as much into this half hour as humanly possible, so you can continue the conversation on your own time with James or Tamar, member of their team. Again, as Tamar just mentioned, ltdfaq.ca. You can use that absolutely free and anonymous, as is mydisabilityquestions.com. But a little closer to home and more familiar, maybe the phone number and email, 1-855-821-5900, help@disabilityrights.ca. Thanks for joining us. We'll catch you next time right here on the Disability Law Show.